Sandusky Law Offices. What is a criminal pretrial? Criminal cases can start in a variety of ways depending on the court, whether the charge is a misdemeanor or felony, and who initiated the charge. However, once the court accepts a not guilty plea, the next step in most cases is to schedule a pretrial. The pretrial is simply a meeting between your attorney and the prosecutor to discuss your case. The prosecutor may have more evidence to share with your attorney, and they might discuss potential pleas and other resolutions to your case. What you can expect is to arrive at the court early and check in with the clerk, who will likely show you a waiting area to sit and await your attorney, who will talk to you before going into another room to meet with the prosecutor. While some courts expect those meetings to happen in the middle of a busy courtroom that is conducting a variety of business, most provide a room for them to meet. Once they have met, your attorney will come back to you and discuss the progress of those discussions. If your attorney was able to get the prosecutor to offer a reduced plea or other resolution, they will discuss that with you and help you understand the offer so you can make an intelligent decision whether it is acceptable to you. If an agreement is reached, the court might have you and your attorney go in front of the judge to confirm you reached an agreement, that it is acceptable to you, and that you understand what you are agreeing to. If an agreement is not reached, the court will typically schedule another pretrial or a suppression motion hearing. Those motions are to try to keep out evidence that the prosecutor plans to use against you. Most people want to try to get the charges behind them as quickly as possible, but many times it requires more than just one pretrial to get the best possible resolution for you. So be hopeful that the case can get resolved quickly, but be prepared that it may take more time. Also be aware that you are out on a bond, and the court may have you take a drug or alcohol test while you are there. If the court asks you whether you have used drugs or alcohol, be truthful, because that question is usually followed up with a test. And the court is going to be much more lenient with you if you are honest and test positive than if you lie and then test positive. The court has the authority to revoke your bond and place you in jail if you violate the terms and conditions of your bond. Here are a few pointers. Arrive on time, dress well enough that you appear respectful of the court for the possibility of going in front of the judge. You might also want to bring something to read, as it sometimes takes an hour or more for your attorney to be able to meet with the prosecutor. Remember, too, that most courts now expect you to walk through metal detectors when you arrive, and some do and some don't allow you to take cell phones into the waiting area. Finally, do not hesitate to ask your attorney questions to ensure you are fully informed of the progress being made and the implications of any decisions you are asked to make. It's your attorney's job to share information about the discussions he's had with the prosecutor and to make sure you have the information you need. The attorneys at Sandusky Law Offices provide personalized representation, valued for their experience and respected for their skills. If you find yourself in need of an attorney, empower yourself by contacting Sandusky Law Offices for a free telephone consultation at 800-641-1970.